Good morning, and thank you for joining us. My name is Kelly Weiner, and I'm a partner at Scott Legal PC. And today we're going to talk about the L-1 visa and the EB-1C. A few housekeeping items before we get started. Some of you may know that our law firm was founded on an E-2 visa several years ago. Our founder has been in the U.S. on an E-2 visa and has held several different visas, including an F-1, TN, a B, and an H-1B. The firm is a full-service immigration law firm, and we offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5, and more. At the end of this webinar, we're going to send out several useful tools. One will be the PowerPoint presentation that we go through today. Another will be a link to where you can download guides that go through the visa options in more detail, and also a link to where you can sign up for additional webinars. This webinar will be recorded and it will be made available on YouTube. We will also send the link for that, and we encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. Um, as I mentioned, my name is Kelly Weiner. I'm a partner at Scott Legal with many years of experience processing L1 and EB-1C visas. If you have any questions throughout the presentation, please send them in the chat box or Q&A, and we'll get to them at the end of the presentation. So now let's get started. What is an L1 visa? So the L1 visa is also often called the intra-company transferee visa, and its main purpose is to facilitate the transfer of qualified employees who hold managerial, executive, or specialized knowledge roles from abroad to a company in the U.S. that has a qualifying relationship defined as a parent, subsidiary, affiliate, or branch office. The L1 is available for companies that are opening a new office in the United States. So if there's been a company abroad that's been operating for at least a year or more and wants to send a qualified employee to the US to open a new office, that is possible. A new office is defined as an office that has been operating, actively trading for less than 1 year. It is also possible to get what we call a regular L1 visa, and this is for companies where the company abroad and the company in the US have been doing business for more than a year. All right, let's talk a little bit more about the basic L1 requirements. So one major requirement is there has to be a qualifying relationship between a company abroad and a company in the US. This is going to be defined as a parent, affiliate, branch, or subsidiary. And you do want to actually look specifically at how the companies are related because there are specific definitions in the immigration regulations for what qualifies under these categories. So, for example, many companies may describe each other as affiliates, but again, there's a specific definition in the immigration law for what will qualify as an affiliate, through through common ownership. And so you do want to specifically do that analysis to make sure that there is that qualifying relationship between the companies. Both companies must be doing business on an ongoing basis. So this is defined as the regular, systematic, and continuous provision of goods or services. So you do need proof that the companies are actually, actively trading, doing business. If the U.S. company has not been doing business, so let's say you incorporated, 2 years ago, but it has just been a passive entity, there haven't been any goods or services, the tax returns show kind of zero in revenue. There's kind of no money in the company. That is not going to, qualify for a regular L1. But if you do plan to actively start trading, potentially you could apply for a new office application. So as listed here, if the company's been doing business for less than a year, it's a pure startup, you can apply for a new office application. But there are some additional requirements for this, which we'll talk about later in the presentation. So the employee has to be working already for the foreign company and must have been working for the foreign company for at least 1 year out of the past 3 years. And it can't just be any employee. It has to be an employee that was working in a managerial, executive, or specialized knowledge position. And there are very specific definitions for who qualifies as a manager, who qualifies as an executive. And so it's, somebody who's kind of a low-level manager who, manages people who may not have, professional degrees or who may not be managers themselves. This often can be a challenging case to make for an L1. For the L1, if you're applying as a manager or executive, you can renew for up to 7 years. So generally, you're going for a regular L1, you could get an approval for 3 years and then renew in increments of 2 years up to 7 years. For an L1B, 3 years and then in increments of 2 years up to 5 years. You also can recapture time. So let's say that you spend a few weeks each year outside of the United States, you may be able to recapture that time, to get some additional time on the L. For example, if you're in the green card process and you need to, add some more time before you actually get your green card granted. So you want to keep track of any trips that you take outside the United States, as this may be relevant, in the future. All right, what are the new office requirements? So, a new office is an organization that has been doing business in the US for less than 1 year. And if the company is sending an employee to open a new office, there are going to be some additional requirements. So, one main requirement is proof that the company has secured physical premises that are sufficient to house the new office. So, often the way this is interpreted is they want to see, let's say your business plan says you're going to hire 7 employees in year one. They're going to want to see that you have an office that can actually support 7 employees. Although this has kind of gotten a little bit more malleable in recent years, they often do not like kind of co-working spaces, often receiving a lot of pushback on those types of spaces. So, although hypothetically you could argue, well, I've secured a two-person office and, the office manager says there is space for me to get new offices or get a bigger office as I hire new people. They can push back against that and argue, well, we need to see sufficient physical premises to house the new office and, take into account its expansion plans over the first year of operations. Um, if you are coming as an L1A for it to open a new office, you have to have been an executive or manager for one continuous year out of the 3 years preceding the petition. Um, and the proposed employment has to involve managerial or executive authority over the new operation. You do not have to have employees before you apply for this, but you do have to show that the U.S. operation will support a managerial or executive role within 1 year of approval. So they want to see specific information about what is the scope of the planned office, what is the organizational structure, will there be employees from abroad supporting the U.S. operation, what are the company's financial goals over that first year? Will the foreign company be, adding investment to the U.S. company? Will it capitalize the company and allow it to operate? Um, what is the financial ability of the company to pay the employee and to actually start the business in the United States? So all of these, what is the organizational structure of the foreign company? So this can be very helpful to say, okay, there's no, for example, administrative employees yet in the US. We're going to hire one by the end of the year, but in the meantime, we will have administrative support for the executive, working abroad. And really, by the end of that first year, in your business plan for an L1 new office, you really need to show that the company is going to hire enough people that the executive or manager is really focused on those executive or managerial tasks. So if you are arguing that the person is going to come over as a CEO, but you're only in year one going to hire one administrative assistant, they're not going to believe that at the end of the year, the CEO is only doing executive tasks or primarily doing executive tasks, because they will feel, well, there's just one administrative employee. So the CEO is probably doing sales and operations and things that fall outside of the scope of that somewhat rigid definition that they have, of executive or manager. For an L1B new office, this is when a specialist is coming over, somebody who holds a specialized knowledge role within the company. And for this, you still have to provide proof that you have secured sufficient physical premises and also need to show that the company has the ability to pay the employee and to commence doing business in the US. Sometimes the government will come back and even try to argue, well, you need to show us that, the foreign company, is going to capitalize the US company with the total amount of expenses for year one. We have successfully pushed back against this argument. We think this is some overreach by the government because that's not what's in the regulations. But it is just to show that kind of capitalizing the US company, by transferring money or showing the foreign company has made this money available and there's kind of signed letters from, the board or the CEO, or management of the foreign company that this money will be available to the US company as needed. All right, what is the definition of executive capacity? So as discussed, executive capacity has a very specific definition. It is listed here. So an executive is someone who directs the management of the organization or a major component or function of the organization, establishes goals and policies of the organization, component or function, exercises wide latitude and discretionary decision making, and receives only general supervision from higher level executives, board of directors, or stockholders. So very important to kind of read this in detail. And when you're describing the role, really focus on to what extent the executive is doing these types of things. So the government will often say, direct the management of an organization. If there is not management in an organization underneath that executive, they may not accept that the person actually is an executive. So you need to kind of think about what is the structure of the company, how many employees does it have? Is this person truly an executive the way the government is defining it? Because they will not just rely on the job title. It is really going to be about the substance of the job, what they're doing on a day-to-day basis. And if the structure really doesn't support an executive because it's such a small company, you may want to try for a different type of role, a manager or specialist, as opposed to an executive. All right, what is the definition of a manager? So a manager, managerial capacity means an assignment in which the employee is primarily managing an organization or a department, subdivision, function, or component. So this is important, to kind of read this carefully because there is kind of a personnel manager, so a manager who's really focused on managing, people, employees, and there's also a function manager. So this is a manager who may not have a lot of direct reports, but is in charge of managing a major function of the company. So let's say if you have a finance department, maybe the VP of the finance department who is kind of making the decisions about how that department is going to run, but perhaps does not have does not actually have a lot of direct reports. That could be a problem. Um, so supervising the work of supervisory, professional, or managerial employees. So that's kind of personnel manager again, or manages an essential function within the organization. So a function manager is often going to receive more scrutiny, potentially more pushback. This is something where you do have to provide that evidence that they are managing the function and not performing it. So that can be a very, kind of tight line to draw. Often it's done by pointing out the indirect reports who are doing a lot of the work. Managers should also have the authority to hire and fire or recommend other personnel actions. Obviously, again, this is related to those personnel managers. Um, who are directly supervising employees. If no employees are supervised, the way that you prove this is you show that they function at a senior level within the organizational hierarchy. So are they, having conversations with kind of the C-level executives or other senior managers about how this function is going to operate within the structure of the company? Sometimes you can demonstrate this with work product, with showing the meetings that they're attending. So those are all important things to keep in mind. Exercises discretion over the day-to-day operations of the activity or function. So again, if this is someone who's a personnel manager, are they kind of making decisions and sending, things to their direct reports where they're the final line of decision making for that particular department or function? And important to note here that they specifically say a first line supervisor will not be considered acting in a managerial capacity if they are just supervising kind of employees who are not professionals or supervisors themselves. Professional employees are considered those whose jobs require at least a bachelor's degree. All right, so what is specialized knowledge? This is for an L-1B, so you can only get 5 years under this category. Specialized knowledge can also be quite difficult to prove. There's a very specific memo that kind of came out several years ago that defines kind of how the government will look at these petitions, but they are very document intensive petitions because you are having to show that this person has special knowledge of the petitioning organization's products, services, research, equipment, techniques, management, or other interests, or an advanced level of knowledge or expertise in the organization's processes or procedures. So generally, the one of the challenging things here is you actually have to show that the person's knowledge is not commonly held throughout the industry, or for advanced expertise in the organization's processes and procedures that it's not commonly held throughout the company. So you are kind of comparing this applicant to their peers and trying to argue that this specialized knowledge they have, is different, is more advanced, and has this extremely beneficial impact on the company. So, for example, it's not a requirement that the person have specific knowledge of kind of proprietary products. But if there are proprietary products and the person had a major hand in developing them, and is, much more experienced in them than anyone else in the company, that's going to be, a more compelling argument for an L-1B. Similarly, if the person, maybe it's a company that was a startup and kind of grew very quickly, and that person kind of started with the company and was really, an important key person in developing processes and procedures that are now driving this company's large growth, that can be another argument that can work well for a specialized knowledge application. All right, so turning to the actual application, what documents need to be submitted? You do have to submit a form to U.S. Citizenship and Immigration Services. This is called a Form I-129. You can also potentially apply for premium processing, which is where the government will issue a decision within 15 business days for an additional fee. That decision can be an approval, denial, or request for more evidence. You have to provide the documents that prove all the elements we just talked about. So corporate documents showing the qualifying relationship between companies, proof that the companies are doing business. So you want company tax returns, audited financial statements, lease agreements, invoices, payroll summaries, maybe business bank statements. There's kind of no one thing that's absolutely required, but there's some common things they would expect to see, like those tax returns, like those audited financial statements if the company is doing business. Um, Proof that the employees worked for the company abroad for a continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. Most commonly, this is going to be pay stubs. If you have personnel records, to prove the person was, an executive, manager, or specialist, you're going to need to have a detailed job description, organizational charts showing, where they sit in the hierarchy. Work product can also be very helpful in proving that the person meets one of these criteria. And then you have to also show the person's role in the US is going to qualify as managerial, executive, or specialized knowledge. And here you're going to include a lot of similar things to what you would include for proof of the role abroad. That being said, let's say the role in the US is slightly different. You're going to have to adjust for that. And if the role is significantly different, you also want to address how the person's prior experience has qualified them to do this new job in the US. So let's say you have a senior manager in abroad who is being transferred to an executive role in the United States. You're going to have, two different job descriptions showing how they meet the managerial criteria abroad, showing how they meet the executive criteria in the US. And those can be a bit more work because you are, not able to just say it's the exact same job. You do have to show how the person will be able to hold that role in the United States. All right, requests for evidence. So requests for evidence are unfortunately rather common for L1 petitions. They have dropped, over the past few years. So, from 2019 to 2021, RFE rates were extremely high, over 50%. More recent data shows RFE rates, more in the 30s instead of 50s, although we do anticipate some uptick, based on executive orders asking for more, more scrutiny on all immigration petitions. Um, Most of the RFEs, even if they have kind of other components, will challenge whether the person meets that definition of manager, executive, or specialized knowledge worker. It's kind of something they throw in there very frequently, again, because the definitions are very rigid. So detailed support letters are important. Support letters that have examples. So they're very sensitive to kind of these overly generic, job descriptions. The person, does business strategy. What does that mean within this particular company? So it's very helpful to provide context for what type of business this is, and then provide some specific examples. So if you say that they're going to, liaise with major key clients, who are these major key clients? What does liaising mean in this industry? Why does that meet the definition of executive or manager? So you do want to provide that context. Organizational charts are very helpful. Also, you want to supplement this with objective evidence. So, very, often they will say, you know, we don't want to just take your word for it, essentially. So just submit, if you get a request for evidence, just submitting a job description letter and an organizational chart, is not as compelling as being able to say, here is some work product that was produced a year ago that shows this person is, the major decision maker for our finance policy. So that kind of objective work product, proof of that they have a department, and within that department, everyone they manage has master's degrees. These types of objective evidence are very helpful to have a successful request for evidence response. All right, let's talk a little bit about timing. So for L-1 petitions, they do have to be approved by U.S. Citizenship and Immigration Services. Processing times are generally several months, but many companies will, want the certainty of the timing, and so they will pay this additional fee. Right now, it's $2,805 to get this answer within 15 business days. As I mentioned, it can be an approval denial, request for evidence, or notice of intent to deny. If it's a request for evidence or notice of intent to deny, you are going to be submitting a response to this, and then they will usually issue a final decision within 15 business days after receiving the response. Very infrequent, but every now and then they will also issue a second request for evidence. So very, very infrequent, but just putting it out there that it is possible. After the L-1 petition is approved, so if the applicant was in the United States, in a valid non-immigrant status, like they came on a B-1, maybe they're on, an H-1B, they can change status to L-1 status. Another potential option is that once you get your approval, you go to the consulate and you get a visa stamp in your passport. When you go to the consulate, they should not be re-adjudicating the L-1 petition, but they will be checking to make sure that the information that you provide to them is similar, or the same, matches with what's in the L-1 petition. So it's kind of a credibility check. If they say what is going to be your job title in the United States and you're not able to correctly tell them, that will obviously be a problem. So if they notice any inconsistencies, in your explanation of the job, that could be an issue. So you do want to make sure that your understanding of the job is aligned with what was submitted in the L-1 petition. Additionally, they will do background checks, kind of criminal record checks, all of those things at the visa interview. So if there have ever been kind of past immigration violations or criminal history, these things can all be very relevant in whether or not the L-1 visa stamp is granted. That being said, many L-1 visa, interviews are very short and very easy because the bulk of the substantive information has already been approved and they are not meant to be re-adjudicating that. So spouses and unmarried children under 21 can accompany the L-1 on L-2 dependent visas. Spouses do get the benefit of being able to work. They used to have to apply for work authorization, but now they can just have work authorization based on their L-2 spouse status every time you enter the United States. You want to check your I-94 to make sure you are given that annotation L2S, and that will give you that ability to work. And if you were not given the annotation, you can contact a deferred inspection office of Customs and Border Protection and ask them to fix that for you so you can have proof that you can work. Children are not permitted to work, but can attend school on the L2. So how long can an L visa be issued for? So the L1 approval, as I mentioned, if it's a new office approval, you get 1 year. If it's a regular L, you can get 3 years. However, the length that the visa will be issued for is going to depend on the reciprocity schedule of your country. So, for example, there are some countries, Korea comes to mind where the reciprocity for an L visa is 5 years. That means you could be granted a visa stamp that is valid for 5 years, but it's going to be annotated with a petition expiration date, and that is the 3-year end of your L1 approval. That means that you can get an extension within the United States or another approval. And then you would have to travel with your valid visa stamp and your new approval notice. Similarly, some people, for example, Chile comes to mind, will only get a visa stamp that's valid for 1 year. Again, the 1 year visa is going to be annotated with a petition expiration date showing that you had an approval for 3 years. So when you enter, you can still be given up to 3 years, but you will need to go back and keep renewing that visa. So the visa is this entry document. You need that to be valid to enter the United States, but you need to pay attention to that petition expiration date because that is what gives you the ability to work based on the L. All right, so a very common question, does an L1 lead to a green card? And this is where we're going to talk also about the EB-1C. So for an L1A, where the person was an executive or a manager abroad, they can apply for an EB-1C multinational manager or executive green card. The requirements are very similar to the L1A, but there is a heightened standard because a green card is the ability to kind of work and live in the United States permanently to eventually apply for US citizenship. And so even if, like, let's say you got your L1A, but it was a fight. It was very difficult, very extensive request for evidence, and you ultimately got it approved. It may be quite difficult to apply for the EB-1C. Depending on what the circumstances are, you may want to wait until the US company is kind of running and more robust. That being said, when you apply for the EB-1C, they will look back at your employment abroad. So if the employment abroad was the issue, so if you kind of, barely proved that you were an executive or manager back when you were working abroad, it may be difficult to get an EB-1C. So you do want to kind of keep that in mind, the strength of the L1 petition, and then also knowing that just because the L1 was approved, it does not mean the EB-1C will be rubber stamped. That being said, it can be a great option. And the EB-1C, is in a green card category, the EB-1, that is one of the only green card categories right now that is kind of not backlogged worldwide. So this can be a very attractive option. Similar requirements, so there has to be that qualifying relationship between the company abroad and the US company. Both companies have to be doing business. A difference here from the L1 is the prospective US employer must have been doing business for at least a year. So if you get a new office L and you say, I immediately want to file my EB-1C, that's not going to work. Your US company has to be doing business for at least 1 year. The employee has to have worked in an executive or managerial role for at least a continuous year in the past 3 years. If you have been in the US on L1 status for, 5 years, this doesn't preclude you from getting an EB-1C. The dates will be adjusted, based on when you entered the United States, as long as you kind of continued to work for that same employer. So if you left and worked somewhere else and now you've come back, that could be problematic. But if you entered on the L1, you've stayed with the company the whole time, they will adjust the time for the employment. A major benefit here is there is no labor certification required. So many of the employment-based green card categories, like the EB-2 and EB-3, require that the company do a labor market test and prove that there are no willing, qualified, and available US workers for the job. The EB-1C does not require that. So that's a large benefit of this. You can kind of go ahead and file your I-140 petition. Often you can concurrently file a green card application, if you're kind of in the worldwide, category and not one of the backlog categories, like people who were born in India or China. And you can pay an additional fee to get a response within 45 business days, for the EB-1, for that I-140. That does not mean you'll have your green card in 45 business days. It means the I-140 can be approved within 45 business days, and then your green card application will continue to pend, and hopefully be approved. Processing times are often somewhere between kind of 6 months up to even, 2 years, depending on which field office and service center it's being adjudicated at. So for the L1B, they may not have this option. If you were not a manager or executive abroad, that was not the role you held, you had a specialist role, and now you're here on an L1B and you don't hold a specialist role. You hold a specialist role and you do not hold an executive or managerial role, you will not be able to apply for the EB-1C. However, you could still go through the PERM process. That's kind of under the EB-2 or EB-3 that we talked about. This is where you do have to do that labor market test. You do have to actually go through all the steps for the perm labor market test, including getting a prevailing wage, waiting for that, conducting that labor market test, filing a labor certification with the Department of Labor, waiting for that certification, then filing an I-140, and then filing a green card down the line. But unfortunately, right now, both the EB-2 and EB-3 categories are backlogged by a few years. So if this is something that you're interested in, you do need to kind of plan, ahead of time and kind of make sure you're starting that process early enough that you won't experience any gaps in work authorization. All right, we've come to the end of the presentation. We'll see if we have any questions. It appears that none have come in, so we'll close here. Thank you to everyone for joining, and I hope you have a wonderful day.